Dina Rose. She was a juror in the Adam Waldron trial. She was in the stairwell at the courthouse talking loudly about the trial and how they thought the evidence presented was bullshit. Adam Joseph Waldron. That's you, sir?
Yes, sir.
You're charged here with attempting to influence jurors. You did willfully attempt to influence the decision of a juror in a case or argument that was not a part of the proceedings in open court. They charge this as a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. I haven't seen this case charged in many, many years, but it is still on the books. The prosecutor has agreed to reduce that to a charge of attempting to influence a juror. There is no
an attempt to influence.
I don't know if there is such a thing. I don't think there's an attempted attempt. The attempt would be 180 day, but I don't think you could do an attempt of an attempt. You've been in custody for 64 days.
Yes, sir.
So attempt to attempt, I don't think that's a valid charge. So it would have to just be attempt, which would be a 180 day maximum offense and a fine of up to $500. Do you understand?
Yes, sir.
Other than that plea offer, did anybody promise you anything to get you to plead to this
No, sir.
or threaten you?
No, sir.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Harden is here with you. You could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come and testify under oath. You'd have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you, and you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. Do you understand?
Yes, sir.
Now, I heard about this when this went down. Judge Stutzman was not very happy about this.
Yeah.
You were having a trial on a resisting and obstructing charge, is that correct?
Yes, sir.
And then before the jury had reached their verdict, did you have some discussion with the juror in the stairwell?
No, no, sir.
Tell me what happened.
I was actually talking to my family. Like they're here with me today. My dad was on the left, she was in the middle, and I was on the other way around. My dad was on the right, my dad's old lady was in the middle, and I was on the left. I was talking to her the whole entire time. All right.
Well, were you talking about how unfair all this was, and it was all travesty of justice, and the jurors were there?
No.
Well, all right. Let's take a look at the affidavit and see what that says. Spoke to Dina Rose. She was a juror in the Adam Waldron trial. She was in the stairwell at the courthouse, talking loudly about the trial and how they thought the evidence presented was bullshit. Dina said at the bottom of the stairs was another juror, and the defendant spoke directly to that juror. Also, the other juror was anyway, this was a security breakdown. This shouldn't have happened anyway. But apparently you were expressing your opinion about your trial, and the jurors were present in the hallway when that happened.
No, I was talking to my dad.
Okay, you were talking to your family, but it was within the earshot of the jurors.
They shouldn't even be around me.
Your Honor, it doesn't sound like we have a plea.
Yeah, I wouldn't argue with that either. In order to do this, you got to admit that you did something wrong. It says here, you're saying this trial's a bunch of bullshit and the jurors were there and they were uncomfortable by it. Now, you can certainly express your opinion to your parents about that.
Yes, sir.
You can say whatever you want. But they ended up having a mistrial and had to start all over again.
Yes, sir.
So the judge was not real happy about
Yes,
this.
sir. I like to be honest with you, I like to try to get a dismissal on this case.
All right, well, they don't want a dismissal. What they were recommending, I think, is time served.
Yeah.
So, but at this point, you haven't acknowledged anything. Another option is you could plead no contest to this charge. By pleading no contest, you don't admit what happened. You also don't deny it, and you would allow that a conviction would enter. Are you willing to plead no contest to this charge?
Yes, sir.
All right. Have you been sentenced on your other cases yet?
No.
It's still pending. I know Mr. Knopfsinger's his attorney. I've been reaching out to him as far as a status update on that. I know he's still in negotiations with the prosecutor.
I was just trying to be done with no. I know I talked to Luke. He came to see me last Thursday and he said he would dismiss this charge and plead the R&O down to a misdemeanor and get time served, no probation.
That's not the information I received, Your Honor.
Well, I don't need to know that. I don't know what it is. And unless the matter is resolved this year, it'll be in the province of the new prosecutor. I'll show this as a no contest plea. The very first case I tried in December of 1981.
I wasn't even born. I wasn't even born.
I get that a lot.
I was born in 95.
It was a very complicated case involving a set of identical twins and a fraud, and it had 76 exhibits, 27 witnesses, and I'd had my bar card for about 2 weeks. But I'd worked on it the whole summer before. I did the whole trial, and one of the jurors made a date with one of the witnesses in the parking lot. Her car wouldn't start, and he went over to jump her car. And they started to talk, and he was married. Anyway, they made a date to meet after the trial was over. So I tried the whole thing. The guy was convicted. It came to light that one of the jurors had made a date with one of the witnesses, in fact, one of the key witnesses, and the case was mistried. So it was a big mess. Ultimately, he did get convicted, but the case was reversed for other considerations. Craig David Neeland was the name of the defendant. I won't say the name of the juror or the witness.
Your Honor, could I ask for sentencing purposes that any allowable fines and costs that the court can waive be waived?
Yes, I'm going to order 63 days in jail, credit 63 days. This is another one where this case doesn't make a lot of difference. The minimum fine of $125 for 2 additional days. Once again, Mr. Waldron, just about everybody this morning that's been in custody, we took care of a matter and it's one less thing they have to worry about.
Yes, sir.
I would suggest in the future, you wait till you get out of the courthouse, in your car, say whatever you want.
Yes, sir.
Don't do it in the hallway in front of several jurors.
This short exchange reflects a moment of professional advice given in a serious setting, likely around a courthouse environment. The speaker is cautioning the other person to be careful about where and when they speak. Instead of saying something, in the courthouse hallway, where conversations might be overheard or misinterpreted, the speaker suggests waiting until they are outside and inside their car before speaking freely. This advice highlights how sensitive legal environments can be, where even casual remarks might carry consequences. The conversation ends on a respectful note with, "You're good to go," and "Thank you," indicating that the situation was handled calmly and professionally.